years before secondary legislation is there. So that is a very important issue as well. And then the accessibility of the legislation to those in charge for enforcement. Once someone told me a story about a judge which was implementing a law and was making a ruling based upon a law which had already been superseded by another law 3 years ago, but the judge wasn't aware or wasn't informed. So accessibility of legislation to those in charge for the enforcement. So what we are saying here today is that parliaments have a responsibility to monitor that legislation is implemented as intended and have some effect. So it's not only a job of government, but it's also a job for parliament. So post-legislative scrutiny is a dimension of the work of parliament, and it has two main areas, two main dimensions. The first, post-legislative scrutiny, looks at the enactment of the legislation. So this is the legal dimension. So looking if all secondary legislation has been issued, if the law is compatible with the Constitution and other legislation, whether there are any relevant court rulings which interpret the law in a certain way. Post-legislative scrutiny also looks at has the implementing agency been established? So for every law there is an agency, an institution, an office responsible to ensure implementation. Has this office or the agency been established in a timely manner? Or if it is an existing institution, a department, an office, has this existing institution been sufficiently resourced to take on board this additional task of implementing this law? And have the relevant targets groups been notified? So these are all the aspects which can be analyzed when looking at the legal dimension of the implementation of legislation. Now, this is only one of the issues, and this is often one of the things which legal analysis and also parliamentarians sometimes look at, the enactment of the law, and that is good. But that's not the only thing. Actually, the main one is looking at the impact of the legislation. So after a number of years, how can we measure whether the objectives have been met? What are the lessons learned from implementing this law? Or there may be certain gaps which can be identified and which need to be remedied. Now, this is, let's say, the general framework on post-legislative scrutiny. I'm going to give you a couple of examples of different countries where post-legislative scrutiny is practiced in very different ways, also from different continents, to give you a kind of picture as broad as possible. So these are the four countries which I will talk about. So starting with the United Kingdom, what is interesting in the United Kingdom is that there is a quite specific mechanism in place to ensure Parliament's role in evaluating implementation of legislation. And it starts with the role of the government. So the government, the ministries, the departments, they are responsible to propose an initial memorandum on the implementation of every law minimum 3 years after it is enacted, after it enters into force. And so the government, the department, sends this memorandum to the relevant committee in the House of Commons, in the Parliament. And then the committee looks at this memorandum. Sometimes they say, it's a very interesting piece of information, we are very happy with it, so we have a very good picture of how this law is being implemented. However, very often they say it's an interesting piece of information we received from the government, but it's incomplete. It's maybe not entirely impartial. So we want to start our own review, our own assessment of the implementation of legislation. And so the relevant select committee is then conducting its hearings and its oversight. Now, if the relevant committee takes that on board, that is one way to go. However, if a relevant committee does not take the issue forward by reviewing the impact, any other committee or even the other house, in this case then the House of Lords, still has a possibility and does actually exercise its right to do its own examination of implementation of laws. And so that results then in a number of hearings, resulting in a report, often a very extensive report, with recommendations, findings and recommendations. Now, this is being conducted by the standing committees, so the thematic committees in the House of Commons. In the House of Lords, there is a different approach. There, for assessing impact of legislation, there is formed a temporary committee, an ad hoc committee, and they need to conduct such a review within 1 year. And so they use a very similar approach. They do a call for written evidence, for written documentation, which can be uploaded automatically on the committee's website. Then there are a number of hearings, a lot of questioning, and then they come up with a report with recommendations to specific departments in the government and various other state agencies. Now, this report is not the end of the story. So these reports are not written in order to be put to the archives. The government is required to respond within 2 months to the findings and the recommendations of this report. So the government needs to explain whether it accepts each of the recommendations, rejects them, or partially accepts them, and then also give an explanation, a justification for acceptance or rejection. Now, to give you a concrete example and making it a little bit more concrete, and also since this is a conference on human rights, I wanted to share this topic with you. So in 2010, the Westminster Parliament adopted the Equality Act. And so the Equality Act is a law which ensures equal opportunities and combats discrimination on various grounds. So based on discrimination based upon gender, age, race, disability, sexual orientation, any form of discrimination is being covered in this law. So it's a very comprehensive law. Now, because it's so comprehensive, it's very hard for one committee to analyze the impact in all these fields. So they decided to focus specifically on those provisions regarding disability. So in other words, how are persons with disability, how are they not being discriminated, how are they being given equal opportunities? So they launched a call for written evidence. They got 144 written responses. So one was from the ministry, the memorandum, and then 143 came from various other stakeholders and researchers, civil society, and various interest groups. All of that has been published on the website of the committee, and then they are organized from these 144 submissions, 13 public hearings where 53 stakeholders were heard in person. And the result was what you see here on the screen, a report of more than 170 pages with various assessments on how the Act affects people with disability. Now, within the question of equal opportunity for persons with disability, there was one issue which catched the committee's attention in particular, and that was the issue of access to taxi transport. So the committee was informed that persons with a disability, particularly persons sitting in a wheelchair, had a lot of problems getting a taxi. So calling a taxi company, very often the company would decline and say, sorry, we cannot do that. Or they would say, yes, of course, we will pick up this person, but we are going to double charge because, you know, there is this wheelchair, which is, of course, a very clear case of discrimination. So the committee questioned the minister and said, look, the law is very clear that this should not happen. What have you done as government to address this question? The first time the minister came to the committee, he had all kinds of excuses, saying, well, you know, this is a bit a complicated issue. It's a matter of, you know, mentality of people. It's about, you know, cultural. It's about circumstances. It's about, I mean, nothing we can do as politicians to enforce this. The committee did not accept that response and said, sorry, minister, that's not enough. You have to go back. You need to come with new initiatives. The second time, the minister didn't have, again, very much to tell the committee. So the minister had to come back a third time. that time, indeed, very specific measures were announced as being enforced. So that means that the minister had written a very strongly worded letter to the Association of Taxi Companies, informing them that this is the legislation which is in force and they have to abide to. And secondly, also specific guidance was given to the police that they are entitled to issue fines to companies which are not abiding with the law. So with these very concrete measures, the minister indeed could demonstrate that this article of the legislation is now in force. And I think it's a concrete example how post-legislative scrutiny can actually contribute to improving conditions for the most vulnerable in society. So coming back to the UK Parliament's approach, so as I said at the beginning, so all acts receive post-legislative scrutiny within the government and are then considered for further scrutiny within Parliament. Some of these laws require more in-depth parliamentary scrutiny, but of course they're trying to look to it proportionate to the need. But the initial responsibility lies with the government, with the departments, to prepare such a memorandum and provide the first. So we can see that the UK Parliament is a formal scrutinizer in post-legislative scrutiny, in the sense that it is quite established in terms of structures and procedures on post-legislative scrutiny. Now, this is one parliament which I wanted to elaborate and also give some examples. I also will elaborate on a couple of other practices in other more recently established parliaments. And one of them is Moldova. Moldova is a former Soviet republic in East. So it's less than 30 years, almost 30 years. And so they have established an interesting methodology on post-legislative scrutiny. So they have outlined requirements, the procedures, and their approach to conduct post-legislative scrutiny. And also identified the responsibility of everyone in Parliament. So from the Speaker of Parliament, deputy speakers, to chairpersons of committees, members of Parliament, to the heads of different departments, up to the communications department, everyone in Parliament of this post-legislative scrutiny. Now, what is interesting is that they have determined that for every law which is in place, 1 year after it is voted in Parliament, they conduct a legal assessment. So they assess whether the secondary legislation, other laws, etc. So the Parliament's legal department conducts a legal assessment. And then the thematic committees then do an impact assessment after minimum 3 years. So looking how the objectives have been implemented. So this is the methodology they have adopted in the Bureau of the Parliament, and these are the results. It's a very recent initiative. It only exists since 2 years. And so in 2000, so the conclusion is that from these 19 laws, 15 of them have a degree of implementation between 80 to 100%, which is not bad. However, they also identified that 2 of the 19 laws have only an implementation below 10%. And the reason is that no secondary legislation was available, no budgets were allocated, and actually the law far. For this year, 2019, 54 laws are currently being examined in terms of their legislation. So it's a small parliament, it's a small country, but they're moving forward quite decisively in assessing impact of legislation. Third country I want to speak about very briefly is Cape Verde, which has adopted in 2011 a law on gender-based violence. And so in 2014, 3 years later, the Women Caucus, the group of all women parliamentarians, came together and they said, let's analyze what has happened in these 3 years. And this is the first time ever that the Parliament of Cape Verde did a post-legislative scrutiny exercise. They did various hearings. They did also a lot of field visits, 22 field visits throughout the country. And what they found was quite shocking. They were quite shocked to identify that actually nothing had happened in these 3 years. So no single regulation was issued, no budget was assigned, and as a result, the implementing agencies, the agencies responsible to ensure implementation of the law, didn't move. The Women Caucus didn't leave there. They actually started a campaign to have an increase of the budget. So next year's state budget foresaw a considerable amount of for implementation and enforcement of the law on gender-based violence. So regulations were enacted, budget allocated, and also a roadmap on national gender policy and gender budget was adopted, which was also for the first time in Cape Verde in 2016. And then the fourth country I want to speak about is Uganda. In 2010, they adopted a law on the prohibition of female genital mutilation after a lot of debate. And this law criminalizes FGM, governs the prosecution and punishment of offenders, and provides for the protection of victims of female genital mutilation. Now, also this was adopted in 2010. So a couple of years later, 2 years ago, the Research Department of Parliament has then conducted a study. And so they found that FGM had declined, it is less present. However, there are some unintended consequences as a result of this law. And so what happened is that the practice has gone underground in some areas. So that means that certain persons were actually continuing but hiding. And so another important point of the conclusion is what is actually undermining the effectiveness of this law. First, it has to do with perceptions that female genital mutilation was part of local culture and therefore should be accepted. That was the first finding. The second is that there is low level of public awareness on the issue. So for instance, the law had not been translated in various local languages. There was also reluctance to report specific cases to the police because of fear for reprisals within the local community. And then, of course, failure to assess the financial implications of fully implementing this law prior to its being enacted. So then the Parliament Research Department identified a couple of lessons learned. First, of course, the importance of conducting a sensitization campaign in a more broad way before such a law is being enacted, and of course also after the law is in force. A second lesson learned is the assess the financial implications in much more detail. And then the third one is also recognizing the limits of legislation to address such an issue, which is quite deeply rooted in traditions and customs. So legislation on itself is not sufficient and has its limits. So these were four country studies or country cases I wanted to mention to you. So what have we learned so far? We've learned that PLS is not a luxury good beyond the reach of newer or less established parliaments. Also, parliaments at various stages of institutional development have undertaken PLS successfully. And the reason is that they've done it successfully because it's done in a very different way in different countries depending on their political system. So the critical question is not whether to undertake post-legislative scrutiny, but rather how to do that. And so on the question how to conduct post-legislative scrutiny, so at the Westminster Foundation for Democracy, we worked with many of our country offices. We have offices in around 33 to 34 countries at the moment. And so with several of our colleagues, we worked at identifying principles of post-legislative scrutiny. And so I'm going to present very briefly the main principles of how post-legislative scrutiny can contribute to rule of law, human rights, as well as governance in general. And the first one is that it's very useful and convenient to have a binding requirement to conduct post-legislative scrutiny. And there are three ways to to ensure a binding requirement. And the first one is, of course, to ask the government, to ask the relevant minister, when a new law is introduced in Parliament, to ask the government to make a commitment that they will evaluate this law after 3, 4, 5 years. So when the minister commits officially on the record in a debate, this is written down in the transcripts of the debate. So you have a ministerial commitment. So it's binding, but binding in a political way. A second is actually making it binding legally by including in the legislation a review clause. So a review clause stipulates as an article of the law at which moment in time, when, by whom, in which way an evaluation of the impact of legislation needs to be conducted. And that has the force of law, and it's of course very stable. One can also go one step further for a binding requirement, and that is a sunset clause. So that means that legislation automatically ceases in its effect after a specific period unless there is a review. And this review is conducted and has concluded that the law needs to be kept in place. So that is an even stronger incentive to making sure that there is an evaluation conducted. While it's useful to have a binding requirement, it is not absolutely necessary. So our second principle is that Parliament has the power to undertake post-legislative scrutiny on any matter, even if there is no explicit binding requirement as the three I've mentioned before. And the reason for that is because post-legislative scrutiny belongs to the oversight role of Parliament, the way how Parliament is exercising control over the government. And so what Parliament then needs to do is identifying the trigger points, the issues which are triggering Parliament to come forward and initiate a review of legislation. And these trigger points can be, let's say, and some parliaments have stipulated that in their rules of procedure, that these trigger points can be specific requests of citizens, associations coming in, based upon media reports. In some countries it is the judiciary, the state prosecutor, filing an annual report to Parliament, which then includes a chapter on challenges with implementation of legislation. Or it can be, of course, as the result of the regular oversight role of the various committees. Our third principle is that it's important to look at primary and secondary legislation at the same time. So very often, a lot of issues, as some people would say, the most important issues, are put in secondary legislation. But that has its challenges as well, because we see that in many countries there is a temptation for governments to put as much as possible in secondary legislation and keep primary legislation rather vague. But that has risks. And one of the risks is that secondary legislation might divert from the original purpose of the primary legislation. Secondary legislation might even contradict primary legislation, or it might also turn out that there are certain gaps, certain omissions which are not being addressed. So reviewing primary and secondary legislation at the same time ensures that the post-legislative scrutiny will be comprehensive. The fourth principle is that PLS provides an opportunity to assess the impact of legislation on issues which cut across different acts, such as gender or on minorities. So we all know that legislation affects men and women differently. So how exactly does it affect men and women and other demographic groups differently? And how can we address or redress some of the disadvantages being created? So these are key issues which can also be asked in PLS inquiries. The fifth principle is PLS is looking at impact of legislation, but is not trying to redo the whole policy debate at the time when the law was adopted. So very often when laws are adopted, it can be quite controversial. It can be quite tight. Sometimes the vote can be very tight. So post-legislative scrutiny does not aim to redo the whole debate. So post-legislative scrutiny is looking at the impact of the law, whether we like it or not. And that's particularly a challenge for opposition MPs, which of course are against specific legislation. Post-legislative scrutiny does not reopen that debate, but tries to measure impact as objectively as possible. Our sixth principle is the importance of public engagement in PLS. PLS is not the property of Parliament only. It's even not the property of the government only. It belongs to everyone, and everyone can have a contribution to that. So public engagement, involvement of civil society, academics, and various other sources of information is important because it adds credibility to the findings and enhances also public trust in institutions. And our last principle here is that we suggest that PLS takes place at least 3 years after the enactment of the law. So this is the question, when should this happen? It's very hard to make a general time frame which is applicable to all circumstances, but the underlying message is that there needs to be sufficient information and data available about how the law works in order to be able to assess its impact. So 3 years is a rule which is applied by many countries around the globe, and so which we also suggest here as a useful point of measurement. So these are the general principles. I want to say also a couple of words. I'm coming slowly towards the end of my introduction. A couple of words on the question of PLS and gender analysis. So when we look specifically at gender-related legislation, I've come across many countries which have perfectly drafted legislative text as far as gender equality is concerned. And very often a lot of international efforts and domestic efforts are inviting and drafting a very solid legislative text on gender equality. However, the implementation is often poor and very poor. So in terms of PLS and gender analysis, we are outlining here two kind of categories of laws to take into account. The first is what I call legislation which has not gender specifically targeted. So that means general legislation on health, education, taxation, economy, any topic, and how we can have a gender mainstreaming approach to that piece of legislation. How does this very general piece of legislation affects men and women differently? And that in itself is already a first approach. The second is looking at legislation which specifically targets gender questions. So legislation on gender equality, legislation on gender-based violence, and how can we assess the implementation of this kind of legislation. And so I have here a couple of approaches on gender mainstreaming approach to PLS. So in Parliament, I think it's important to identify which is the relevant committee in charge for assessing impact of a specific piece of legislation, and how can the committee to make sure that there is a gender mainstreaming approach. So if it is a law on education, you work with the education committee. If it is a law on taxation, it's most likely the finance and economy committee. So working and liaison with these committees. The second is including gender-relevant objectives, questions, and indicators in the terms of reference of such an assessment. So in order to be as specific as possible, you need to have specific questions in order to have specific data. Data collection. It's important to have basic data, additional data, and then sex disaggregated data. What are issues on which you want to have specific information for men and women? Sources of information. Diversity of sources is important, so we have outlined a couple of them here. Also, choosing stakeholders for public hearings, and we have done some interesting research in the UK on the profile of who is actually invited to Parliament to give testimony. And so we found out that the profile is quite male-dominated, and then very often male from the capital, so or people living in the capital. So how can we make sure that those people invited to testify for Parliament is more equally spread throughout the country, as well as between the different genders? A couple of other approaches to gender mainstreaming. Field visits is important, but also it's important to make sure that they are gender inclusive. Communication is very important, but also it's useful to have a gender-specific targeted communication on this PLS inquiries. And then drafting gender-relevant findings and recommendations. The way how findings are formulated is an art in itself, and I think also there are very good practices on how they can be made gender-specific. And then finally, forwarding the report to gender-assigned ministries and requesting for a response, and also the public launch of the response. So these were the main issues I wanted to share with you today during my presentation. There are quite a number of other issues we can still talk about, but I'll leave that for the Q&A session. And before that, we have, of course, the contribution of my colleagues as well. I hope this general introduction on the role of Parliament in post-legislative scrutiny was useful for you. I tried to give an introduction on general practices globally and in different kind of parliaments, and I think it will be very useful to continue the debate and see how is this going to be relevant here in the context in Indonesia. Thank you.
Thank you very much, Franklin. That is what we call as a grand theory of PLS. So now we will move on the context of PLS in Indonesia. Before Mas Agus presenting his paper, just to remind you all that 3 weeks ago, the Center CSRM organized a workshop with the National Commission on Women's Rights, or Komnas Perempuan, on the protection of women in East Java, and I was really shocked because Komnas Perempuan identified that East Java has a red light for the protection of women, because one, there are some laws that discriminate against women, and then the second one is the CSO is silent. So now we will see what we have done. I mean, the WFD in Indonesia have done so far in promoting inclusive legislations. I mean, inclusive local legislations. I give you the floor.
Thank you, Mas Hanif. This is the most difficult time to make a presentation, actually. You know, after lunch, everyone seems to be after lunch, about to be closing the events. All the factors are there. But I hope that everyone is still with us. I was joking with Hanif when we had the darkness, that I rarely claim that I'm a graduate of the university. No, not at all. In Indonesia, we believe, as a Javanese, we have a saying, hujan batu di negeri sendiri, hujan emas negeri. So gold rain in other countries, or the stone rain in our own countries. We still love our own countries. So I still regularly come and contribute to the university because I feel like, okay, so I sometimes miss the misery that I had when I was studying here. So, okay, so this is the outline of my presentation. I'm going to share the context first, then we will share what we have done so far and what we are planning to do, and how can we try to seek possibility to work together between our our programs and our researchers, somewhere here in Indonesia, or work that is being done by our colleagues in Sydney University or in other university. So the context is, this context is based on policy economic analysis that we did. So we did kind of research to actually assess the situation before we started our program. So in Indonesia, we have a robust decentralization since 1999 after the fall of the previous New Order regime. People want to decentralize. We have passed 3 laws to actually give wide regional autonomy to district level. So the authority, quite a lot of wide autonomy is given to the district level. District level, district government and parliament can pass their own regulation to regulate their own public services and kind of that. However, the central government want to keep control of that decentralization by, because we have what we call a unitary state, that even though it is widely decentralized, most of the affairs, but it has to be regularly scrutinized by the Home Affairs Ministry. So that's the concept. In Indonesia, the legislation making is also standardized. The parliament, the national parliament, and the government pass a law on how to make a legislation. So everyone has to comply on that. In Indonesia, because everything is standardized, we are so positivist, everything is written. Unless it is written somewhere in the law, then people, even if it is written in the law, people do not obey sometimes. So we put everything in written. So all the system of pre and post legislative scrutiny are in place. So every draft regulation, every draft law or a draft local legislation or even ministerial regulation have to be scrutinized, pre-scrutinized. So all the draft regulation which is prepared by the local parliament have to be scrutinized by the Ministry of Home Affairs or by the provincial government. There's also a post-legislative scrutiny, the process where after a law is being implemented, it has to be evaluated. It is already written in the law on parliament since 1999. However, not until 2014, the national parliament is actually implementing that. So it's there in the law, it's regulated, they can do it, but they don't use the power. Only in 2014, then it is clearly written in the law on parliament that the legislative committee or the Badan Legislasi is the one who must do an evaluation of past law, particularly on the legal aspect. And the committee, the subject committees, is the committee which is responsible to do an evaluation of the implementation of the law by looking at the impacts, by looking at whether or not the objectives of that law have been achieved. It's there, again, but subject committee have never done it. If they do it, only 1 or 2 committees, but mostly our parliament are very busy in making new laws all the time, but they forget we still have laws passed in the 60s, in the 40s, which is there, still valid, but it's not applied at all, for example. Not only the parliament, which has the authority to do all that, the Ministry of Home Affairs have the power to do a pre-legislative scrutiny. The Ministry of Justice and Human Rights has the power to do a pre-legislative scrutiny. Later, just now in 2018, the upper house, it's not actually the upper house, the House of Regional Representative, the house which represents provinces, also have the new power to evaluate, to do a pre and post legislative scrutiny of secondary legislation. Then the Ministry of Home Affairs previously have the power to revoke any local legislation which is considered to be not inconsistent to the national law or contradict the national law. The power is there. But since 2016, 2017, the power is stripped by the Constitutional Court. At the moment, the only institutions which have the authority to review the past secondary legislation is only the Supreme Court. Another problem is the Supreme Court is different from the Constitutional Court. The process of judicial review at the Constitutional Court, when they are, when people are not happy with the law, they can file a complaint to the Constitutional Court. The process is open. There's an open hearing where people can make their cases. They can defend with their lawyers and so on. But in the Supreme Court, it is a closed chamber, just like a very high appeal that someone submit their complaint, then after a year, suddenly there's a, there's a decision, there's a verdict, or nothing at all. So that's make the situation even more complicated. A next context, regardless of all those, so many institutions is involved in the pre-legislative scrutiny, and there's now, at the moment, there's only one doing post-legislative. But still, there's a fact where thousands of local legislation are still passed, and they're discriminating minorities, they're discriminating women. Komnas Perempuan, or the National Commission on Anti-Violence Against Women, found 431 local legislations with, can penalize women because, they are not wearing, headscarf, for example. So it's real discrimination, hundreds of them. The National Commission on Human Rights found 3,200 local legislation which discriminate, which contradict human rights, which does not protect human rights and doesn't fulfill human rights, for example. So there are many of them still haven't. In fact, the process of pre-scrutiny is done. The Ministry of Home Affairs is doing it, the Ministry of Justice is doing it, but yet the products of legislation still have a lot of issues. So because of that context, what we did first is we tried to find out what are actually the factors, what are the real causes of that situation. So that's what we are trying to ask ourselves with our team. Then the second that we wanted to do is how can we try to solve the problem. So that's two things is the question that we want to try. So what we did the last 2 years is we tried to do it into these three activities. One is we work closely with the National Parliament, the Legislation Committee of the National Parliament to do a post-legislative scrutiny or evaluation of the law on lawmaking process, how it is implemented, what are the causes. So we work together because WFD is not the Parliament, we don't have the authority, of course, so we just design and we use the hands of, we mastermind. No, that's not a good word. So we supported the Legislation Committee. So they are the one who actually implement the process, but we provide support. We collaborate with Hanif Center to provide evidence, to support, to do some research, to support them. We also do series of focus group discussion, public hearing, we invite civil society to come to the Parliament to testify, but then everything is done from within the Parliament, so it is the Parliament which doing that. What we found, so the finding is that the Ministry of Home Affairs, when they are doing a pre-legislative scrutiny, mainly they focus only on three areas. They don't, thousands of local legislation has passed, but Ministry of Home Affairs focus only on draft local legislation concerning budget, draft local legislation concerning special planning, and draft local legislation concerning tax retribution or anything that will charge the public. There are three areas that Ministry of Home Affairs focus. The rest, no. The guy is here, so we can also hear from him later. Secondly, the Ministry of Home Affairs and the provincial government, they don't have enough staff. Their staff is very limited. The number of staff are limited. Even worse, from those limited staff, not a very small number of them are actually having a legal basis or having the capacity or the legal background or, as a legal drafters or, so that's another situation because people can sit there, transfer from somewhere else, their mutation is happening very regularly. then usually it's not actually looked very carefully that this is actually the person meeting the qualification to be an evaluator of this. So that's the second finding that we had. The third, normally, Ministry of Home Affairs or provincial government, they do post-legislative scrutiny if it is a national priority, instructed by the President. For example, President Jokowi wants to delete as many as local legislation which prevent investment, which avoid investment to happen quickly. So suddenly 1,300 local legislation was revoked by the Ministry of Home Affairs. So it is not done through a systematic process, but okay, what is my boss wants, so we do it. Next is on, similarly, provincial government, they usually do it because, there's, a guidance or instruction from the Ministry of Home Affairs. So local parliament in Indonesia is seen as a part of local government. Local government is not afraid of anyone else except the Ministry of Home Affairs. So if the Ministry of Home Affairs send invitation, then everyone will come. But if it is the Westminster Foundation invite them, expect no one showing up. Or even other ministries. So if it is other ministry inviting them, but if it is Dr. Rosie Beni who invite them, trust me, 514 local parliaments secretary will come. So the boss are there because they are the one who can do anything they want. Is that true, Pak Ben? No, I'm just opening, the reality, and we have the suspect, the defendants there. What are the other things? I have mentioned that. So at the moment, actually, the subnational parliament already have the power to do a post-legislative scrutiny. Legally, it's there. However, the local parliament does not even know if they have that power. So we have met with 65. We have given training to 65 local parliament in 3 provinces, and none of them are actually aware of their new power. So they have that power, and they don't even know that they have that power. The other thing is another issue is overlap between disharmony between legislation. So we have a law on decentralization. We have a law on lawmaking process. Both law is not in harmony. It creates power to the Ministry of Home Affairs, and it also give another power to the Ministry of Justice. What happened is last year, the Ministry of Justice issued 2 ministerial regulation which require every local legislation to be pre-legislative scrutiny by the Ministry of Justice. 2 weeks after that, his boss, the Minister of Home Affairs, write a letter to that ministry saying that you are overstepping your authority. So this kind of things happen among ministries within the same cabinet under the same president. So that's fact. So that's a competition between units, competition between ministry. It's happened. And when I talk about competition, when there is a power, it's always have a budget implication. So running that power means we are running money. We are running our budget. So that's why they want to keep silos. So that's the finding that we really had so far. Works done under the initiative so far. What we did, we tried to promote implementation of post-legislative scrutiny by the subnational parliament. How? We work with Center for Human Rights, led by Dr. Hanif. We work with the National Parliament, the Legislation Committee, the National Commission of Anti-Violence Against Women. We focus on discriminatory local legislation against women. That's our focus. So we have been doing it. What we did, we tried to mainstream that into the process. We trained 65 local parliament, I told you already, in collaboration with the institution that I mentioned. Second thing that we are doing, we try to clarify the new role of the upper house, the deputy, because it creates another confusion. There has been so many agencies working on post-legislative scrutiny. Now, the parliament add a new player, which is the upper house. But there is no clear process of doing it. So they don't know how to do it. And the last 1 year we have been working with the upper house to create internal working mechanism. We produce manual, we try to help them in actually implement that. And the last thing that we did, it was passed into 24th September when everyone is focusing on, students are protesting on the anti-corruption law, the KPK law, and students are protesting on the penal code. Then not hiddenly, but at the same time, the parliament actually passed a law on lawmaking process, amended the law on lawmaking process, and adding a new practice, which is evaluating legislations. It is now obligation that every government institution, every parliament's already done it, but every ministries, local government, they have to do a post-legislative scrutiny. So now there's a legal basis, there's an opportunity that it is done nationwide. What action we are thinking of doing? So at the moment, CHRM and WFD are planning to pilot this new role. So we will work with a number of local parliament to actually pilot, implementing it. We will support them. We will help them in maybe producing the manual, actually doing it. So that's the plan that we are doing. We do it with the support of the CFLI program of the Canadian Embassy. The other thing that we are in the beginning of doing it is we work with the Ministry of Home Affairs on how to make that national policy become really implementable, because it can be written, as Franklin said, it can be written in the law. It can be, the law has been there, but not necessarily that it's going to be implemented, because they don't pass the secondary legislation, they don't allocate budget for that, things like that. So we agreed, Minister of Home Affairs agreed that we are going to work together. We will support them to actually encourage local parliament to undergo the post-legislative scrutiny. The third thing, unlike the national parliament, I've been traveling to a number of parliament, supporting a number of parliament, not only in Indonesia. I have to say that the Indonesian parliament, the national parliament, is the most resourceful. They have so many thousands of staff, much bigger even as compared to the UK House of Commons. They have 81 researchers, some of them professors, PhD from somewhere else. But the problem is all those support system, almost 250 functional support system in the big center, they don't actually produce policy analysis which is needed by the parliament. The researchers are the researchers whose promotion are under the Indonesian Institute for Science, LIPI. So in order to get promotion, publication is there. And when they mention publication, is their science, development of the knowledge that they're doing. So they don't care if what they are producing is actually going to be used by the parliament. But they are the researchers of the parliament, but they're doing publication for the sake of making publication. So that's the real situation in our national parliament. Unlike the national parliament, the local parliament have almost nobody. So there's MPs. Some parliament has 35 MPs, even 100 MPs. But normally in one parliament they have only about 4 to 5 staff based on the party caucus, not on the committee. So they don't have that. So that's why we expect that the Ministry of Home Affairs later will be willing to actually allocate resources for the local parliament to implement their work. That's why if it has become national policy endorsed by the Ministry of Home Affairs, then it's become possible to be funded. My challenge is that whether it is possible to make researchers, academia at the local university, because we work with the local parliament of Jember, for example. They have no resources, they have no people. We are thinking of, is it possible that university research centers like CRM or others will be willing to reorient their research? Not only, yes, it is important for developing the science, yes, but policy is also something which is very concrete. The real needs are there. There is no support, and I think bringing university research into policy-making process by linking directly to the real need at the parliament will be very important. So my question, will it be possible? I'm worried that, like what happened in the national parliament, even they are researchers of the parliament, they are doing research as if they are actually researchers under the university. They don't support their boss, which is the MPs. So that's actually what I wanted to share with everyone in this. So this is what I expect to get answer later. So this is the Madris saying to say thank you. Matur saklangkong. So, and that's, thank you.
Thank you, Mas Agus. You remind me with Susan's argument yesterday about the extractive industry. So I can convince myself and also him that it is not about extractive industry. We still have an ethical and professional work to because we just don't want to let our parliament like behind us, because the policy is there, the authority is there, so we have to include them in human rights advocacy. So the question is also, is PLS or the evaluation mechanism really working? I can convince you it is yes. So one of the witnesses is here, Pak Kadar from Sumeneb. So he joined our workshop 3 weeks ago with Komnas Perempuan, and then he just told me that when he shared with about the evaluation mechanism with his colleague in Sumeneb district, and then principally everyone in his office is really welcome, because they just don't know about why we should have this kind of discriminative laws, because they just don't know. So that's why they enact like Perda Diniyah Tak Miliyah, or maybe like local laws on the allocation of some budget for Islamic education, something like that. They just don't know. So that's why we passed these laws. So actually the third presenter should be in our book of abstract is Mbak Kharirah Ali, but since yesterday she must join the test for because she is running for the commissioner of the Komnas Perempuan. So she cannot. I'm sorry to say that, because to be honest, I must be honest with this situation. So then WFD discuss how then we can include Pak Beni, because he is also one of the most important persons in this mechanism. So Mbak Riri cannot come, and then she is really sorry not to be here. But it will be really good if we have 4 presenters, and then include also Mas Beni, yeah? Okay, so now it is time for us to see whether the government, our government, is angry with us or not. Because since yesterday it is, we have been talking about the state, about the government. If we have human rights violation, it is the state, yeah? And you belong to the state, you represent the state. Okay, now time for you to present your ideas.
Good afternoon. I would like to thank you for Mr. Not Al-Bakara, but Al-Khanib, and Mr. Agus and Mr. Franklin and everyone was organized this forum. I guess this forum is very important to increase the local law performance in Indonesia. If the presenter had previously conveyed the role of parliament, so this time I would like to present about the role of government, or especially Ministry of Home Affairs, in overseeing the implementation of regional regulation or local legislation, maybe. Okay, my presentation about based on 3 topics, and the first about responsibilities for the implementation of government affairs and guidance and control of local governance management, and then guidance and control of subnational regulation. Why national government taking guidance or taking control subnational regulations? Because in Indonesian Constitution addressed that the President of the Republic Indonesia holds government authority according to the Constitution. It is fundamental law in Indonesia. So national government is very deep to intervention in local legislation. And then the President holds the final responsibility for the administration of government affairs carried out by the central and regional government. And then, for this reason, we have authorities to taking control or to develop or to give advice regarding local legislation. As you know, in Indonesia, there are classification of governmental affairs. There is absolute government function is the authority of central government, and concurrent affairs is governmental function, which are the authority of local government and perform based on the autonomy principle. But as we know that regional autonomy in Indonesia within framework unitary state of Republic of Indonesia. So the final responsibilities on President. On behalf, we Ministry of Home Affairs on behalf of national government. And then, in the context of concurrent affairs, there is 32 affairs in local government. So many business in our life and everything of public affairs must be arranged in local legislation. So, who taking control to ensure that the local legislation is adapted with public needed? That's why our authorities in Ministry of Home Affairs to taking control and to give advice to guidance the local legislation implementation or in drafting local legislation. And then why national government taking control or give advice and etc. Because all government function is distributed to regions are essentially the governmental function possessed by the President, and then the President issues the implementation guideline of governmental function and also performs supervision to this implementation in local regions. The guidance and supervision to provincial governments are performed by our Ministry of Home Affairs, and then to regency or municipalities, regency and municipalities governments are performed by the governors who are assigned as the central government representative in regional. Thus, the relationship among the president, governor, and head of regencies or mayors is applied in complementary ways or hierarchical ways, maybe. Okay, this is about the problem of subnational regulation. The first subnational or local government is property management. Subnational property management is about asset and ATC. And the second, permit fees, retribution, and local taxes. And the third, prohibition of community diseases as prostitution, immorality, gambling, alcoholic, and the religious issues, maybe, ATC. And then the fourth, discrimination. I think this topic is a mainly topic of this forum. The fifth is the consequences of constitutional court decision and the consequences of the issuance of new regulation. For this reason, we concern and certainly as soon as we can to solve the problems. This is a subnational regulation problem in regional autonomy era, lack of involving civil society, and then lack of public consultation, and responsible actors not implement or improve subnational regulation, and then lack of control of subnational regulation implementation, and never evaluates its effectiveness. And a number of legislation that are not running with various reasons. So, guidance for the implementation of government is including, this is a division of government affairs, regional institution, staffing in the regional apparatus, regional financing, regional development, public service, regional cooperation, regional policies, includes subnational regulation. And then regional head and local parliament, and then other forms of coaching in accordance with statutory provision. And Mr. Agus, this is the reason because of the interrelationship of the matters. It is the cause of the regional governments in Indonesia faster respond to invitation our direction from government. Not because so many affairs under control in national governments, so many issues, and then. And about competing among governmental officials, so I prefer to use the term of synergy rather than competition. So synergy of blah blah blah. Okay, this is the main substance in the development of subnational products. That is our authority to develop or to guidance subnational regulation. The first guidance of draft. Why we guidance draft? Because in the last time, Constitutional Court revoked of our authorities, revoked our Ministry of Home Affairs and Governor in cancellation of regional regulation. So we have to guidance of subnational draft, or the term of Mr. Agus is free legislative scrutiny, or executive preview. Yeah? Executive preview, that's a guidance of subnational regulation draft, and strengthening subnational regulation development mechanism, and cancellation of subnational regulation except local legislation or perda, ya. Other perda, except perda or except local legislation, we can cancel it. And then this is the instrument of our authority to development local legislation is consulting, and then facilitating, evaluating, verifying, and registering, and the final term is clarification or clarifying. This is draft, just only draft, and then this is the after approve and declare. So our authorities is more in executive review. Consultation is a direct or indirect action taken by provincial government or governors to the central government or regional government, regency, municipality, includes a local parliament, to the provincial and or central government. So there are hierarchy. Regarding drafting, subnational regulation. Facilitation is writing guidance, and evaluation is assessment and evaluation of certain local regulation, and registration is giving a number in the framework of supervision and orderly administration to find out the number of draft regulation issued by the regional government prior to the enactment. And then verification is in action to compare the result of facilitation with the draft subnational regulation before being given by registration number. So regarding subnational only subnational registration drafting. And then clarification of regional legislation or perda. Our Ministry of Home Affairs clarification based on initiative of community complaint. Initiative of community complaint or initiative of government or local government. So this is and the clarification is made within a period of no later than 15 days from receipt of the clarification letter from the initiator. And then government, on behalf of the Ministry of Home Affairs and Government, issued a clarification letter that contains recommendation for revocation of local legislation no later than the formation of pre-local legislation or properda or prolegda, no later than the formation of pre-local legislation the following year, or this instrument to encourage legislative review. Because we have no authority to revoke the legislation, the legal legislation. And in the event that the regional government doesn't follow up on recommendation, on our recommendation or clarification result, it becomes an evaluation material for the regional government's performance. Or simply the term is sanksi, sanction for the regional head or local parliament. And then beside of the national government authority, there are authority of the local parliaments to increase local legislation performance. That is to control the function of regional host of representative or local. The function of local parliament is supervision the implementation of subnational regulation, and then reviewing subnational regulation, and then assessment of the effectiveness of regional regulation. And then, beside local parliament, there are authority, or there are authority of community participation in the formation of legislation, local legislation. Is community participation in regional government includes drafting regional regulation and policies, and then regional development planning, budgeting, implementation, monitoring, and evaluation, management of regional assets and or national resources, and public service delivery. This is the public right to participate. And then in this moment, I think this forum is very important to morally louder. We have to discuss as loudly as every moment, not only on campus, not only in the university, but every moment, every public sphere. We have to be far to solve the subnational regulation problem. All of us have to translate public feeling into the text subnational regulation. I think this important point. And conclusion is development of subnational regulation product have to be adaptive and responsive, and then subnational regulation products sometimes are unique and casuistic, so special guidance and control are needed. And subnational regulation product must at least meet to benchmark aspect legality or rehmatic hate, or beneficiaries, dogmatic hate, and fairness. Meeting these three aspects requires the synergy, Mr. Agus. Meeting these three aspects requires the synergy of the parties or authorities, not comparing, but synergies. And then continuous monitoring and study or evaluation are needed to collect factual data and information. And the final session, I want to quote Agent Ehrlich's opinions that the center of development of law is not located in legal studies. It is not located its constitutional decision. Is not located in court decision, but it on the community itself. So enough is enough. We need to come together to stronger stance, produce and increase local legal quality and its performance. And then beside all the things that can be done by the government, the discussion about the control of local regulation must be louder, not only in the campus, but in every public arena. We have to doing the work. We have together and to translate public feeling into the subnational regulation. Thank you.
Thank you very much, Mas Benny, my colleague. I think I need to remind you all that what Zainal Abidin Bagir shows in one slide of his presentation, which shows that there are some indicators which indicate that some right is going up and some right is going down, and some in a very constant or static pace. And one of these is civil rights. And I do believe that why we have this kind of different phenomena is because the politics of populism is increasing and getting more popular. So where local government, local parliaments, when they have authority, they don't care much about human rights, about civil rights. So what they care much is about their constituent, their voters. So what and then what they must do is how then they convince their voter that what the policy that being taken by the government is good for the majorities. So that's why I do believe that even though in 2016 the Komnas Perempuan indicate that there were more than 421 laws across Indonesia discriminate against women and minorities, and I do believe, still believe in my heart that the number of discriminative law is still increasing. So that's why we need to evaluate the impact of the laws that has been enacted by the local parliaments and local governments. Okay, now time for us to have Q&A. So please feel free and raise your hand. One, please.
Thank you. My name is Abi. I am working for the Ministry of Justice. I'm seeking for an advice from Mr. Franklin. So I would make a quick introduction that regarding disability law in Indonesia. So in 2016, we just passed the new Indonesian with Disability Act. Actually, it was introduced by the civil society. They came to Congress to discuss about the new Indonesian with Disability Act because we have ratified the UNCRPD in 2011. That is why we need more technical regulation, which is the Indonesian with Disability Act is expected to support the implementation of the CRPD in Indonesia. And the problem is in regarding the scrutiny of the Indonesian with Disability Act is it seems that the disability issue is not, I would rather say, is not sexy within the parliamentary discussion. That is why we have extra parliament, which is DPOs, Disabled People Organization, and CSOs, always come to the Office of Ministry of Justice, and they will ask about how's the progress of the implementation, and they also come to the Ministry of Education if the law is, if the provision is connected to the education program. So my question is, how do you see this kind of phenomenon where the parliamentary function on scrutiny of the Indonesian with Disability Act is probably, I will say, is malfunction, and what kind of suggestion can you give to us, especially for me as the implementing agency, as one of the implementing agencies of the Indonesian with Disability Act? Thank you.
Okay, I think, is there any more question? Yes, please, yeah.
Evan Doran from Sydney University. Thank you to all the speakers for excellent presentations. It's not so much a question as a request for additional comment, is also addressed to Franklin. Principle number 5, where you, about the principle of not relitigating the arguments for and against a particular law. How can you avoid that when it would be so tempting for legislators to get stuck back into it? Thank you.
One more question? Okay, yeah.
just small question. My name is Yantaro from Jogja. For Pak Penny, I think, from Ministry of Home Affairs. Please give us a explanation of how you manage your institution. I mean, how you manage consultation and the process of, the interest of the local government and parliament, because you have to handle, many regions in local government. So how do you make all of your job effectively? Thank you.
Okay, so, there is one more question, please.
Hi, I'm Elizabeth from the University of Sydney, and my question is for Dr. Benny. So you outlined the processes or the ideal process for making regional legislation, but I'm interested in your interpretation or your take on how you can disentangle that process from politics and corruption and the power that different parties are trying to exercise through processes and budget making as well.
Okay, so I think we give 4 and then I give you to answer. Who want to answer first? Franklin?
Yes, thank you very much for these 2 questions. First, to the colleague of Ministry of Justice. It's an interesting question. I mean, first of all, I think it's very important that this Disability Act is indeed being evaluated on its impact. If there is a strong interest with you as within the implementing agency to do so, then I think that is a very important thing. In my introduction, I mentioned that within the UK system, every ministry is required to prepare a memorandum. Every department is required to prepare a memorandum of implementation of legislation, which they are then offering to the Parliament for further review. So if there is a strong interest on your side, I think nothing stops you from making on the side of the government an assessment on implementation of legislation and consult with a number of relevant stakeholders and come up with a solid report which is then being published. At the same time, during the consultations, you can of course also engage, I would say, with the BALEC, the legal committee, as well as with the administration, the Center for Post-Legislative Scrutiny in the DPR, which, and the fact that you then engage with them would actually be already an encouragement for them to actually see whether the Parliament itself would be interested to make its own assessment. But I think from on your side, it doesn't, if there is not immediately a strong engagement on the side of Parliament, that should not stop you of developing your own report based upon consultations with various relevant stakeholders. On the question from the colleague of the University of Sydney on one of these principles, I was referring to to the principle as it was identified by the UK Law Commission, that post-legislative scrutiny should not reopen a policy debate. However, of course, a post-legislative scrutiny exercise comes up with findings and recommendations, and these findings can identify certain issues regarding gaps in legislation, contradictions in legislations, maybe issues which have been forgotten, or maybe circumstances which have changed, the context which has changed. And so these recommendations in itself can then actually provide useful guidance. In some circumstances, it might lead to an adaptation of the policy or a changing of the underlying policy, if that is the conclusion of the review. But in principle, I think post-legislative scrutiny looks at the impact of existing legislation. But not necessarily aiming for changing every legislation.
How we manage it, please help me. Please help us. Okay, we manage it by the step-by-step and hierarchies. And in regency or municipal government, taken by a governor. Taken by government via Biro Hukum and etc. And then national government or Ministry of Home Affairs taken manage only to presidential government. But it's not enough, I think. I agree with you. With your mind, it's not enough. Because of that, we have to be, all of us have to be offered to contribute the subnational regulation issues. And then Miss Elizabeth, so our national government, including Division of Government Affairs, regional institution, how to control the corruption in ATC there. I think political party and ATC. In regional autonomy, beside of national government authority, there are local government authority to control the implementing of local governance in Indonesia. In national government, Ministry of Home Affairs to just give advice and sanction if the regional head or local governments take corruption and etc. And then there is important authority in Indonesia depend on regional government law. That's what okay. In the context of regional legislative assembly or local government authorities, they have authority to supervision or control the regional head. They can propose the dismissal of the regional head if the regional head violates an oath or promise of office. So local governments can propose dismissal to the local government propose to the national government or Mahkamah Agung, Supreme Court, to dismissal regional head if their regional head violates an oath or promise of the office. So it's not only national government authority, but local governments is very important rule, very important to control the implementation of governmental affairs in regency or municipal government in Indonesia. So we have to choose the local government yang pintar dan representatif lah gitu. Jangan hanya because the authority is very large in implementation of local government context. I think so.
Okay, I want to help you with one answer to answer the question from that section. Yeah, so
there was law proposals from Jember district on Quranic literacy, and then this law brought to the province of East Java, and then after discussion with the Biro Hukum, legal bureau in the province of East Java, and also from Ministry of Home Affairs, and then they think that you don't need Quranic literacy as a local laws because it is discriminatory, and then decline. But the question is why we have still so many discriminatory laws in other provinces, in other districts. Perhaps from the district levels, and then they go up, and then it is passed by province, and then go to national level, and then done. So even though it is hierarchy, but I think there are some difference. There is I think substantial difference between maybe East Java province and, for example, to say West Java province as one of the problematic province in East Java, in Indonesia, because in East Java itself, in West Java itself, according to the research by Komnas HAM, National Commission on Human Rights, in 2018 there are about 48 discriminatory bylaws only in West Java. So why we still have so many discriminatory laws? I don't know. Mas Agus, do you want to add something?
A question to me. There are two possibilities. There is no question to me. There are two possibilities because my president was super clear, or nothing to us. But it's actually a very interesting thing said by Abi from the Ministry of Justice, that the opportunity is coming. The Parliament has just passed a law which, obliges every government institution to do a post-legislative scrutiny. And if they are doing it, and if every ministry do it like what happened in the UK, that they do, every government have to do it, then submit the memorandum to the Parliament, then the Parliament will have, the ingredients to do it. Don't expect too much to Parliament, because political process very often, similar to what was said by Elizabeth, political process often, overwhelm the process of the Parliament. So if there are ingredients submitted to the Parliament and the Parliament can use it, and civil society will then work together to convince the Parliament to actually do something, then I think there are a number of examples that we already did together with Hanif, with the Ministry of Home Affairs, with our friends in civil society. One of the example is on the amendment of law on counterterrorism. So we work with the Legislative Committee, evaluate the previous law on counterterrorism, then based on that, the Parliament is doing the amendment, and a number of human right perspective is actually included into the process. So, but then we need to be able to work closely with our champions within the Parliament, because political parties, again, even the government sometimes also play politics. To tell you the truth, in our context, I worked for the Indonesian Parliament for 8 years before I feel that I need to get out. So I work from outside. So if, for example, certain ministries cannot pass their draft bill through the Ministry of Justice, because the Ministry of Justice has the directorate which is responsible to include what is the plan of legislation this year. It is under the Ministry of Justice. Some of the ministries will not pass the screening by the Ministry of Justice. Very often the ministry then find the back door through political parties. Then it's become the draft bill initiated by the Parliament, but actually it is fulfilling the certain interests of certain ministries. Not even the ministries, even only certain directorate. Because again, in Indonesia, passing the law, all the budget allocation has to be based on law. There is no spending that is not based on legal, on regulation, on law. So if certain Directorate General want to say, pass, to get more money. They can pass certain law through the back door, then they can allocate budget based on that law. So situation like that also creating difficulties. We can discuss about all the very noble, but when it comes to politics, that's why public pressure, not public pressure actually, synergy between, I like the word, synergy between civil society, research centers, through our champion in the parliament can actually reach a lot of good things. We had a lot of good examples. Our civil society friends are working closely with migrant care. I saw the logo here. Migrant care, eyewitness. Migrant care has been working closely with the committee on manpower, for example, and they have been able to influence the amendment of the law on placement of Indonesian migrant workers abroad from the commodity perspective into right-based approach, which is very good. So that happened. Then if, again, political parties, politicians, very often they're busy with their own agenda, but if we work with support of the civil society and research, I think we still have, out of 575 MPs in Indonesia, we still have quite a lot of them, including the real issues now, I think also in local government, local legislation, because this is also a real problem. WFD with CHRM and the upper house have been meeting with a number of local parliament. Again, that's true populism. We can find, name it, Bali for example, Yogyakarta, we have so many. Bali is a place where a lot of foreign people live there. But in Bali, many districts pass local regulation which discriminate non-Balinese from getting a job, for example, and it's there. In Jogja, for example, there is a local legislation which prohibit certain ethnic to procure land, for example. It's there. So when we talk about discriminatory local legislation, it is not merely about religion or minorities, but including areas like that. The Javanese in Bali is also close to a majority, but not, there are a lot, but they are also discriminated actually in the sense that, so it happened almost everywhere in Indonesia. So if local civil societies can work closely with universities in every region, then we can build a synergy, and I think there are a lot can be done together.
Okay, to respond, Mr. Al-Bakhara. Okay, we no longer have the authority to cancel the local legislation, but we manage by provide recommendation to legislative review, and then reduce the score of performance of local government performance. Karena ada kinerjaan itu, we can reduce the score of local government performance and then push the sanction through parliamentary through local parliament mechanism, and then we can reject their program or budgeting proposal that can support the bad local legislation. I think it's important to how to take in control the bad local legislation, Mr. Al. Reject aja ini. The budgeting proposal.
Okay, because we are running out of time. 1, 2 from Sydney. If we end this session more than 1 hour, I will ask you to provide dinner. Yeah. Okay, just kidding. Okay, 2 more questions, please. Okay.
Hello, thank you so much. Susan Banky from the University of Sydney. I appreciated hearing from Dr. Benny about the the healthy tension that exists between the government and civil society. And we know that there's many models. There's models where there's what you might call the loyal opposition, where the opposition is something that works mostly just to check the boxes that the government wants. There's the healthy tension where there's legislation serves as a friendly battleground between civil society and government. I'd like to ask, and this is a question that any of you can answer, it might be most appropriate for Franklin. What is the role of legislation when the relationship between civil society and the government is more antagonistic? I mean, the one that I'm thinking of is Myanmar because that's what I study. But let me just give you an example from something that you mentioned about the sunset clause. It strikes me that if the government is uncomfortable with the legislation because it contains human rights materials, it will not bother them in the least if the sunset clause removes that legislation from discussion. To me, this actually looks like there's almost an incentive to not pay attention to what PLS could do, specifically for that reason. In a situation where there's a healthy tension, I can see where sunset clause or other aspects of legislation are useful. But where it's more antagonistic, I'm curious what we're left with. Thanks so much.
Thank you. My name is Reni. I'm from WKCP, Wahana Keluarga Cerebral Palsy. It's the community of parents who has cerebral palsy children. I would like to ask to Mr. Benny from Home Affairs. I was just wondering, because as we are from civil society, from DPO, Disabled People Organization, in terms of Disability Act, the law of disability in Indonesia, which is already in 2016, as you mentioned, actually the Home Affairs in national level, it could interfere the local governments, like making the rate mark if they are not implementing some regulation. So I was wondering, is that any possible that because not every regional government in Indonesia has the local law, which is it's impossible to implement the Indonesian Act law if the government in local didn't produce the local regulation for disability. And then I would like to ask also with Mas Agus or Mr. Franklin, you are mentioning that because of the political things that it might be that the government or the parliament will not do have a good initiative for that. And then what can we do as a civil society when both sides didn't have this good intention, for example, where we could complain as in terms of Indonesia? I mean, because we cannot asking for our parliaments or asking for the governments to complain. I mean, we've been in community, I've been dealing with meeting with the governments or also meeting with the parliaments, and it is really like if we have a good relation, personal relation, then it is easier for them, okay, we will try to fight for you. But if it is in other way, that will be impossible for you to sue them, for example, like that. What is your suggestion, or maybe based on your experience, how do we have our rights as a civil society within that terms? Thank you.
All right, so the last question that raised me. So yeah, experience. In a way, I started to work on, parliamentary engagement from inside outside the parliament the last 15 years, and most success story are, were achieved when civil society are working in partnership rather than antagonistic, so that's the strategy. In our context, quite a lot of success story can be done by making friends not with the MPs, but with the expert staff of the MPs and the expert staff of the committees. So in the forum I told about some success that we did, amending the law on, putting post-legislative scrutiny, when we also, a number of laws that we work closely. It is not the face of WFD, but it is a coalition of civil society, work together, and WFD is facilitating regular meetings between the expert staff of that committee, and some expert staff of every fraksi, or in the parliament, every party is represented. They are grouped in the party caucus, and they have about, depends on how big is the party, they have from 25 to about 80 expert staff, and each of them is specializing in certain things. So if we work closely with them, using them as our tool to, they are the one who are cooking. So they are the one who, then the MP is going to just, not to just, but the MP is going to present it. But, if we work with the CEF and we influence the CEF, become mixed friend of the CEF, every progress from within the parliament will get the information. So I think that's the tips that I can share with you.
Yes, on the issue of relationships between parliaments and civil society, or state structures and civil society. I mean, I see at least there are 5 different roles which civil society can play, and depending on the political context. One is where civil society is trying to influence the agenda, so it's lobbying, agenda setting, and some civil society groups are very good in that. Other civil society groups are very good in providing information, doing research, and offering that to MPs, parliament, or state institutions. In other circumstances, you have civil society as an opposition force. They protest. Sometimes it can even go further, and they can try to block through legal proceedings, initiating court cases in some cases, as even we have seen in the UK with Brexit, where actually individual lawyers can actually force government's hand in a certain direction. And then also, particularly I think in the humanitarian sector, where actually civil society becomes service providers. They actually distribute humanitarian goods on behalf of various institutions. So these are 5 different roles which civil society can play. When civil society is outside of the state structures, and sometimes you see in specific moments when a country transitions, when there is a very profound change in the government structures happening, that some civil society leaders jumped and they actually join the government, they become member of parliament, and that is on some very specific occasions that is happening. So it all depends on these specific circumstances. Now, I'm also following closely developments in Myanmar. I've been also there, and then I think that is one of these moments of change, or one of the moments of change which have happened, where some people have jumped, and you see that people with the civil society background can become very influential parliamentarians as well. And we have seen that these heavy institutions with a lot of bureaucracy, it's quite a challenge to open them up. And so what WFD has been doing in the last 2 years is actually working with the Myanmar Parliament in terms of organizing public hearings, organizing inquiries. And so we had the first public hearings this year, actually, 3 months ago, when the Education Committee for the first time organized public hearing on policies of higher education, involving all the stakeholders in the higher education sector. And for most of them, it was the first time ever they visited the parliament in Naypyidaw. The same as we have done a PLS inquiry on the rights of children, which came up with some very surprising findings and recommendations. So there are some openings, but still, there is still a lot to be pushed. The door is open a little bit, but for civil society, you don't walk into the parliament like that in many countries. And so there is still a lot of work to be done. And each of these 5 models of roles of parliament, they have their value within specific context and also based upon qualities of persons and organizations. Some organizations feel very comfortable with doing research and providing that to parliament. Other organizations are more advocacy organizations, and others are real campaign organizations. And every type of organization has its value, and I think it's also complementary. There can even be synergies between different civil society organizations as well.
Okay, about civil society. So it's so important is the role of the civil society. For this reason, in the law, the regional government has a special chapter, has 2 special chapters in our regional law in Indonesia. There's a chapter about regarding civil society participation, and then regional innovation based on civil society purpose. It's so that the civil society is very important thing to support national governments, to taking control, to increase the local governments in Indonesia. Regional government has a special chapter about social participation and regional innovation, and the content is about consists of regional development planning, budgeting, implementation, monitoring and evaluation, and then management of regional assets and HEC or natural resources, and then public service delivery. And about disabilities, we provide later to government and mayor and regional health and emergency regarding affirmation to issues policies that fulfill the protection of disability society. And last reason, and I think to post the local government in Indonesia to make a personal legislation to protect our brother or sister at disability society. Ya, melalui permen KPPA, Kementerian Pemberdayaan Perempuan. Kami sudah support itu untuk menyusun semacam panduan gitu untuk seluruh Indonesia. Tinggal kita come on to together to control, to post, and then the key word is synergy, to post it, not competition.
But still, it is our right to complain to you. Okay, I think it is the end of this session. So we were late 15 minutes from the schedule. I hope it will not be too problematic. For the closing remark will be delivered by Dr. Elizabeth Kramer. So thank you very much for your attention. Give round of applause for the all presenters. I give the time to the committee.
Okay, everyone, let's give one more round of applause for the last plenary session. Wow, what a 3 days we've had. We will have our closing remarks from Dr. Elizabeth Kramer from the University of Sydney, and she will round us out for this conference.
I have the honor of offering some closing remarks for the conference we've heard some amazing papers and panels and plenaries over the last couple of days. And I will get to that in a moment, but I want to be a little bit cheeky and just take this opportunity to explain to you what the Sydney Southeast Asia Centre at the University of Sydney does. I was a little bit caught off guard on Sunday and I forgot to actually tell you what we do. So I'm just going to take a couple of moments to do that. So I work at the Sydney Southeast Asia Centre, or SEAC, we call it for short, where I'm one of the deputy directors there. And we are a multidisciplinary initiative at the University of Sydney focused on supporting research and engagement in the region of Southeast Asia. So we have, I'm not entirely sure what the exact membership numbers are, but we have somewhere over 300 academics at the University of Sydney alone who are members of our centre. They are either conducting ongoing research projects in the region or they have collaborators in the region. And this actually represents one of the largest concentrations of Southeast Asian expertise in the world, and we're very proud of that fact. We have members who focus on issues or have research interests from archaeology to zoology and everything in between. And we're also really keen on building interdisciplinary and multidisciplinary discussions between academics. There's a lot of danger, maybe some academic colleagues have experienced this, where you can become siloed or you can become quite isolated in your particular department or in your particular field. So we're really keen to make sure that conversations are happening between people. We have 5 research clusters, and those are state and society, environment and resources, economic and social development, health and heritage and the arts. So we really have something for everyone. And I really encourage you to just type SEAC into Google and have a look at some of the projects that we're supporting and some of the events that we are sponsoring as well. Okay, so that is my promo spiel. I have to earn my trip here. But I do want to change gears now a little bit and offer some reflection on the last 2 days. There have been a lot of moments, particular phrases that people have used, theories that I haven't come across before, empirical studies that have just been really fascinating. And I think it just highlights how complicated the world that we live in at the moment is and how difficult it is to navigate human rights issues. And, you know, we are all an expert in a particular issue, but it's a really good opportunity for us too to hear what our colleagues are doing, to learn a little bit about something that maybe we're not so familiar with in a particular field or a particular country. And I think this conference in particular has been a great opportunity to do that. I want to come back to, actually quite a few people have mentioned this, even in the past plenary, but I want to come back to a comment that Susan made yesterday in her presentation about us as researchers and what it is we do. And I think she offered a very eloquent warning, caution that the space that we work in can be inherently extractive. And that means that we have to be really conscious of how we conduct ourselves. And not just how we conduct ourselves, but what happens to that information that we extract. What becomes of it, how we make it useful, and how we use the skills and the privileges that we have as researchers and practitioners to affect change. And I was thinking about this last night after dinner, and it sort of struck me that, you know, a lot of us are probably working in this space because, you know, in whatever small way, we want to see a change in the world. And it's not one person that's going to do that, in most cases, I think. But each of us is here because we want things to change. And that's really honorable. And maybe you have other motivations as well, and that's fine. But, you know, that's what motivates a lot of people who work in the human rights space. But there is a flip side to this, and that is change is really difficult. Getting something to change is so hard, and it's tiring, and it requires a lot of energy. And I think, you know, the tenacity and persistence that is required when you are facing issues that are so complicated and power structures that feel really intractable and overbearing is something that we need to be aware of. And so I don't want to be too melodramatic, but I know that I have had moments where I wonder what on earth I'm doing and whether I'm being useful or you know, what am I actually doing here? Does anyone care what I have to say? It's the existential crisis that I that I sometimes dream about at night. And I don't want to be too melodramatic, but you know, on top of those thoughts that might be going on in the back of your mind, we're working in industries that are competitive. The reality is that not every person who has a PhD is going to be able to get a job in academia, and even people who have jobs in academia, you know, they're not 100% secure in the neoliberal university world that we live in at the moment. And, you know, you're having these existential crises, and at the same time, you are thinking about your publications. You're thinking about the student papers that you have to grade. You're thinking about the forms that you have to sign, the committees that you have to be on, because I'm sure every academic is on at least 5 committees, maybe more. And I think probably in the practitioner space, there are very similar issues and pressures on time. So I want to use my closing remarks to remind everyone to be conscious of the toll, the personal toll that working in human rights can have on you, and to make sure that you are looking after yourselves. That you make sure that you have time to step away from the issues, whether that's spending time with your family and friends or your hobbies or whatever it is, just to make sure that you're making that space for yourself, because you're not going to be useful at all if you're burnt out, if you become depressed and pessimistic. So that's the final message that I want to leave everyone with today. And I just had the unfortunate news in a text message about 10 minutes ago that a friend of my partner's and I took his own life a few days ago. And excuse me. He was an NGO worker in East Timor with my husband, and it was World Mental Health Day last week. I wasn't expecting to get so emotional in the closing remarks, but I cannot stress how important it is to make sure that you're looking after yourselves, and to make sure that you tackle the professional hazards of working in human rights as best that you can. And I hope that this conference has given you the opportunity to make some connections, to meet some friends, to find people who are working on similar issues to you, and to build connections and to build a community of practice that can help you to be a better researcher, and to really put the energy that's needed into affecting change. Whew, okay, so before I finish, I want to say a bunch of thank yous. Firstly, to the organizers of the conference, so to the Center for Human Rights, Multiculturalism and Migration, all of the students, all of the staff, all of the fellows, Thank you so much. I know how difficult it is to organize an international conference, so you should be really proud of yourselves. I think the participants have had a great time. I know I have. And not just the panels as well, also the social events and the dinners and the cultural performances. It's been great. And I don't think we've had an opportunity to actually specifically thank Dr. Al-Hanif for his leadership and vision. Thank you very much for being a driving force behind this conference. I also want to acknowledge the collaborative endeavor that this conference has been. So all of the partners, the Westminster Foundation for Democracy, the Journal of Southeast Asian Human Rights, the Department of Gender Studies at the University of Jember, and Sepaham, Indonesia. I think the more partners that you can get involved in these kinds of events and the more people you can bring together is really important for getting, that sort of cross-contamination of ideas and building the community of practice that I mentioned before. I also want to thank, again, my Sydney colleagues who couldn't be here but who were also involved, Professor Michelle Ford and Min and Ariane, who worked on the program and some of the planning. And finally, I want to thank all of the plenary speakers. Dr. Zainal Abidin Bagir, who I haven't seen today, but thank you. And Dr. Susan Banky, and our speakers on the final panel. So Pat Agus, Pat Franklin, and Dr. Benny. I think we've all learnt a lot from the plenary sessions. They've been really great. And finally, thank you to everyone for coming. I hope you had a good time, and I hope you'll tell your colleagues about the conference, and maybe we'll see you in Jember next year. Thanks.
Okay, because, only very short closing, not remark, but it is closing, because it is very common for Indonesian to open and also to close. Usually it is the rector, but the rector is busy because tomorrow is the rector election. So after this, our Sydney colleagues will have a free time, while the Center of Human Rights will still have 2 days more tomorrow and then the next day until Thursday, because we will be having a training session for local parliament members and CSO with Westminster Foundation for Democracy. 2 days more. Okay, do not get stressed, yeah? Okay, one more information before we close our conference. If Dr. Elizabeth mentioned that the SIAC has 300 academia, yeah? While this Center for Human Rights, CSRM, we only have maybe for about 10 researchers, 3 very energetic fellows, Ibrahim, Hannah, and also Deirdre. Thank you for your help, and also we have several research assistants. Is there any research assistants? So please. Okay, Jojon is web designer, and also who designed all of this and a beautiful design. Yeah. So Jojon is there. Please, can you stand up so everyone can notice you? And some others. Is there any? Thank you very much for your passion. I know that it will be not comfortable to sit there alone because you cannot go anywhere. Thank you very much for your passion. And also our best financial officer and also accommodation, Mbak Dina, please can you stand up? Mbak Dina, Mbak Din, can you stand up please? So they are researchers in the center, and we are really thankful to help them because in the last 4 days it is actually semi-autopilot because I have to go back to Banyuwangi, but everything is going well. Thank you very much. So I think we need to close this session, and then after that, if you want to make some photo session, please come forward, and then please, I think we have cameraman, no? Photographer. Oh, okay. After the closing session, we can take picture here and then to just give some memories. Thank you very much. See you next year.